Yes, you can start, beta.
Yes, ma'am. Good afternoon, ma'am. Good afternoon, everyone. Today, today myself, Maroof Arif of Class 11 Commerce. I am here to present myself on the topic intellectual property rights. So let's get started. So first of all, what is intellectual property rights? Intellectual property rights are the rights given to the person over the creation of their minds, such as inventions, literary and artistic works, designs and symbols. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. It is an intangible asset. Nature of intellectual property. Intellectual property is concerned with the creative work. The main property that distinguishes intellectual property from other forms of property is its intangibility. While there are many important differences between different forms of intellectual property, one factor they share is established property protection over intangible things, such as ideas, inventions, science, information, whereas intangible assets in close relationships are a tangible object. It also allows creator or owners to benefit from their works when they are used commercially. Intellectual property gives rise not only to property rights but also duties. The owner of the intellectual property has the right to perform certain functions in relation to his work. He has the exclusive right to produce the work, make copies of the work, market work, etc. Categories of intellectual property rights. Industrial property. It includes patents, trademarks, trade secrets, and industrial design. It gives the exclusive use of the intellectual property for the purposes of making money of the invention. An invention itself is a new manufacture, process, machine, or composition. Second, copyright. Copyright focus primarily on the artistic sector, and their regulation is responsibility of the federal law on copyright, whose objective is to protect authors, performers, and editors' rights concerning their literary or artistic works in all forms. Types of IPR. Patents. It is covered under the Act called Patents Act 1970. A patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way doing something or offers a new technical solution to a problem. A patent is a type of limited duration protection that can be used to protect inventions. Patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the patent's owner consent. The protection is granted for a period of 20 years from the date of filing. What can be patented? In order to patentable, the invention must be new, means it should be already exist in the current knowledge and anywhere in the world, means not in public domain before filing of patent application. It must be non-obvious to any person who is skilled in the relevant field of technology. Finally, it must be capable of industrial application, means capable of being used or manufactured in the industry. Trademarks. A trademark is a sign or a symbol capable of distinguishing the goods or services of one enterprise from those of other enterprise. Trademarks are protected by intellectual property rights. At the national level, the trademark protection can be obtained through registration by filing an application for registration with the National Trademark Office and paying the required fees. Duration of trademark. It is a period of 10 years and its renewal as long as the trademark continues to be used by its owner. These are some brand names and symbols. Trade secret. Trade secret refers to specific information that is important for a business because it gives a business a competitive advantage in its marketplace. These are intellectual property rights on confidential information which may be sold or licensed. Kinds of information protected by trade secret are recipes, new inventions, software processes, manufacturing processes, design that offers an advantage over competitors or provides value to the customer. These are some famous trade secrets. Industrial design. Industrial design is a process of design applied to the product that are to be manufactured by mass production. It is the creative art of determining and defining a product's form and features, which take place in the advance of the manufacture of production of the product. It consists of three-dimensional features such as the shape of the product, two-dimensional features such as ornamentation, patterns like lines or a color of a product. Examples of industrial designs. Copyright. Copyright is a legal term. It is used to describe the rights that creators have over their artistic and literary creation. Duration of protection. For books and other works of art, it is 50 to 70 years after the death of the author. For photographic work, 25 years from making the work. For cinematic works, 50 years after making the work available to the public. These are the things which is covered by copyright. Conclusion. Intellectual property is important for a person or a company to safeguard. Without proper safeguard in place, one company's ideas can be copied by other company and used for their profit. So, the Indian government has initiated various steps to prevent a company's IP from getting into wrong hand. Thank you.